Florida gun laws in 2026 can fool honest people into making one stupid mistake. And that mistake can put you in handcuffs before you even realize you broke the law. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could keep you out of life-changing legal trouble. Hit that button now. Here's what just happened in Florida, and here's why so many gun owners get this wrong. A lot of people heard permitless carry and thought, great, no permit means no problem. But that is not how this works. Not even close. Florida did not turn into a free-for-all state where anyone can carry anything anywhere. What changed is much narrower than that. Florida now allows some people to carry a concealed firearm without a concealed weapon license. The key word is some. And the next key word is concealed. Let me break this down for you. First thing, permitless carry is not the same as legal carry for everybody. If you do not meet the same basic standards required for a Florida concealed carry license, you are not magically protected just because you skipped the permit. That means if you are disqualified because of a felony, a current domestic violence injunction, certain mental health rulings, certain recent drug issues, or another legal block, you can still get charged. Second, Florida still does not generally allow open carry. This is where people get burned. Most people think if a gun peeks out from under your shirt, it's game over. The truth is, a brief accidental display is not the same as true open carry. But walking around with your handgun openly visible like you're in a different state is still a terrible idea in Florida. That can turn into a criminal charge fast. Third, a permit is still useful. That surprises people. A Florida concealed weapon license still matters for travel to states that honor it. It can also help with firearm pickup rules in some situations inside Florida. So no, the license did not become useless overnight. Now this is where it gets interesting. A lot of gun owners focus on the gun itself. They ask, can I carry it? But the smarter question is, am I still legally eligible today? Because your legal status matters just as much as the firearm. If your status changed and you did not realize it, your lawful carry can become unlawful in a second. Here's a hypothetical example to explain this. Let's say a man carried legally for years, then he got hit with a qualifying injunction from a court. He never thought of himself as a prohibited person. He still had the same gun, same holster, same routine. But if he kept carrying after that order, he could be walking straight into a criminal case. But here's the crazy part. Florida's unlawful concealed firearm law can be a felony when the person carrying does not meet the legal criteria. So the state is not just asking, did you have a gun hidden on you? It is also asking, were you someone the law still allowed to carry? That is the first trap in 2026. Permitless carry is not a shortcut around the background rules. It is only a shortcut around the physical permit card for people who already qualify. If you remember nothing else from this video, remember that. Now let's go to trap number 2, because this is the part nobody talks about enough. Where you carry matters just as much as whether you can carry. And Florida has a long list of places where carrying can get you into serious trouble. Start with the obvious ones. Police stations, jails, courthouses, courtrooms, polling places, government meetings, meetings of the legislature. Those are bad places to test your luck. Then there are the places that surprise normal people. School events not related to firearms, elementary and secondary school buildings, career centers, the bar area of a place that serves alcohol for drinking on site, the inside of airport passenger terminals and secure areas, college and university facilities, with only a very narrow exception for certain non-lethal devices. Have you ever wondered why people get caught by this even when they mean well? Because daily life is messy. You're not trying to commit a crime. You are trying to live your life. Imagine you're carrying concealed and your wife asks you to run into your kid's school office for 2 minutes, or you stop at a school event, or you walk into the wrong part of a restaurant and end up in the bar area without thinking about it, or you head to the courthouse to pay a ticket and forget what is on your belt. Those are real-world mistake zones. And schools are especially dangerous from a legal standpoint. Here's what most people get wrong. They think, if my gun stays hidden, I'm fine. No. Florida law on school property is very strict. A person who knowingly has a firearm at a school-sponsored event or on school property can face serious charges. In many cases, that can be a third-degree felony. Even worse, if a weapon is discharged there unlawfully, the charge can jump higher. There's one narrow area that confuses people, so let me simplify it. Florida law does allow a firearm in a private vehicle in certain school-related situations. But that does not mean you can just step out and walk around school property armed like normal. The vehicle rule is not a free pass. It is a narrow exception. If you blur that line, you are taking a huge risk. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Let me give you another hypothetical example. Say you are legally driving and your handgun is in your car. You pull onto school property for pickup. If you stay within what the law allows, that is one thing. But if you grab that gun and step out, or carry it into a school area where it is not allowed, the situation can change very fast. That is how normal people end up needing a defense lawyer. And don't miss this next point. Even if a location violation starts as a misdemeanor, facts can stack up. Add a prohibited status, add school property, add a threatening display, add another offense happening at the same time. Suddenly you're no longer talking about a small mistake. You're talking about a felony arrest, seizure of your firearm, and a record that follows you for years. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it. Now let's talk about the third big trap, and this one shocks people every year. The person who cannot legally possess the gun at all. Not just carry it, possess it, own it, have it in the house, control it. First, felons in Florida cannot lawfully own or possess firearms or ammunition unless their rights were properly restored. Not maybe, not sometimes. That is the rule. And the charge is not small. Possession by a convicted felon is a second-degree felony in Florida. That is not a slap on the wrist. That is a life-changing case. Second, this rule can also hit some people who were found delinquent for acts that would have been felonies if they had been adults, if they are still under 24. This is one of those hidden traps. A person may say, I was a juvenile. That was years ago. But under Florida law, that history can still matter. Third, a risk protection order can wipe out your ability to possess guns while the order is active. If you have never heard that term, it means a court order that temporarily blocks you from having firearms or ammunition because the court believes you are a serious danger. If that order is entered, you must surrender your guns, your ammo, and even your concealed weapon license. You also cannot buy more while that order is in effect. When I found that out the first time, I couldn't believe how many people assume only a criminal conviction can take away gun rights. That is false. A court order can do it, an injunction can do it, certain mental health rulings can do it, federal law can do it. This is why you cannot rely on old advice from your buddy at the range. Now let me explain why this matters even if you think, I'm clean, I've never been arrested. Because legal disqualification is not always obvious. A person can have adjudication withheld on a qualifying case and still have problems for a period of time. A person can have a current domestic violence injunction and not realize that permitless carry does not erase that problem. A person can have recent controlled substance trouble and assume it does not count anymore. That kind of guessing is dangerous. Here's a simple rule. If anything in your record, your court history, or your current legal status makes you unsure, do not carry until you know. I mean really know. Not my cousin says I'm good. Not the guy behind the counter said it's probably fine. No. Now let's hit trap number 4, because this one catches younger gun owners. Florida law still says a person under 21 generally may not buy a firearm from a licensed dealer, with narrow exceptions for certain law enforcement, correctional officers, and service members buying rifles or shotguns. So if you are 18, 19, or 20, do not assume permitless carry means full adult gun rights across the board. It does not. At the same time, Florida does allow some vehicle possession for people 18 and older if the handgun is securely encased or otherwise not readily accessible for immediate use, and not carried on the person unless they are otherwise authorized. That sounds simple, but it creates confusion. Most people think, if it's in my car, I'm safe. Not always. How it is stored matters. Your age matters. Your legal status matters. Where you parked matters. Imagine you are at a traffic stop, and the officer asks if there is a gun in the vehicle. Your answer, your behavior, and the gun's location all matter. If the firearm is lawfully stored and you are lawfully allowed to have it, that is one situation. If it is shoved loose under your leg, or you are under a legal disability, or you are parked somewhere prohibited, that is a totally different story. And here's something even more important. Storage matters in your home too. Florida law has a rule that can punish a person who leaves a loaded firearm within easy reach of a minor. If that minor gets the gun and brings it onto school property in violation of the law. So even if you never carry outside the house, your storage choices can still create criminal exposure. Don't make this mistake. Do not build your whole gun law plan around slogans like constitutional carry or permitless means free. Florida is still full of conditions, exceptions, restricted places, age limits, and prohibited statuses. The law rewards careful people. It crushes careless people. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who get these updates first. Click subscribe. Before I wrap up, I want to give you a simple 2026 checklist you can actually remember. Number 1, ask yourself if you're still legally eligible to carry today, not last year. Today. Number 2, remember that concealed is not the same as open. Florida is still not a broad open carry state. Number 3, memorize the no carry locations, especially schools, courthouses, police stations, government meetings, bar areas, airports, and places banned by federal law. Number 4, if you are under 21, do Do not assume the rules work the same for you. Number 5. If a court order, injunction, felony, or mental health ruling touched your rights, stop and verify everything before you touch a firearm. This is the part that shocked me most. Almost every bad Florida gun case starts the same way. Not with a criminal mastermind, with an ordinary person saying, "I thought I was allowed." That sentence will not protect you in court. Laws change fast, really fast. Subscribe now so you're never caught off guard when the next Florida gun law update drops. So here's the bottom line. In Florida in 2026, the biggest danger is not just carrying a gun. It is carrying with the wrong legal status, in the wrong place, or in the wrong way. Most people don't get in trouble because they plan to break the law. They get in trouble because they guessed. If this video helped you, subscribe right now and share it with one gun owner you care about. You could save someone from a mistake that changes the rest of their life. And one last simple reminder. This video is for education only. Laws can change. And if your situation is specific or urgent, talk to a qualified Florida attorney before you act.